motion was made, seconded, and approved to go into recess. Is there now a motion to end that recess?
So moved.
Okay, motion made and seconded to end the recess at 3:11 p.m. on Wednesday, April 4th. Mr. Wiltie?
Yes.
Mr. Piaquadio?
Yes.
Mrs. Green?
Yes.
Mr. Bello?
Yes.
Mr. Booth?
Yes.
The recess is now ended. Monday night's meeting is now resumed.
Thank you. We did go into a recess. We were all given a couple volumes to go over, which I did. A lot of the information that's been presented prior, both by the town and other applicants. Mark, do you want to explain where we are right now? What we're doing?
All right. The board obviously has had some time to digest statements made at the public hearing and written submissions that have also been made. And one of the primary concerns that it has had in this process is the fact that it must adhere to applicable state laws, and that those laws and the case law have recognized certain rights for applicants. And without belaboring the point, the town has known and been aware of the fact that the Secretary of State guidance documents, as well as case law, if an applicant has achieved vested rights in their application process, then they are exempt from zoning laws, and this moratorium is in fact a zoning law. So, in order to state the obvious, a footnote has been added to the law. And that footnote states that provision that states that no applications will be accepted or processed or permitted approval issued for preliminary or final site plan approval or amended site plan approval, special use permit, or use for variance, interpretation, building permits, certificate of occupancy, or other applicable entitlement which would authorize the expansion or alteration of an adult-oriented business or a new adult-oriented business is subject to exemption for applicants who have obtained vested rights for the expansion or alteration of a new adult-oriented business, or have not obtained decision on their applications within applicable time periods. So, we are essentially, the board determines to act on adding to the local law a footnote which acknowledges what applicants have rights to under state law. And then we've also prepared a revised resolution adoption, which now includes certain findings. And with respect to vested rights, proposed finding, or document states The town board further finds, acknowledges, and recognizes the applicability of the doctrine known as vested rights as set forth in relevant New York and federal cases to this local law. Authority to make vested rights determinations with respect to applications has consistently been placed with and exercised in the Town of Newburgh by the code compliance supervisor, an independent officer of the town and the person in charge of the enforcement of zoning and other code provisions, who has the ability to render decisions with respect to the applicability of local law provisions to applications. That authority includes this local law. And again, is consistent with its practices. In accordance with such finding, acknowledgement, and recognition, an applicant has the right to request the code compliance supervisor or his designee for a determination regarding vested rights in any pending or future application to the Town of Newburgh with respect to the applicability of local law number 2, and to submit relevant evidence in support of the claim, including but not limited to records of expenditures incurred, construction and improvements made, and permits and approvals obtained pursuant to which the work was performed. Again, that is something that applicants have the right to do. We're stating what should have been known by applicants already, the fact that they determined to not acknowledge that is somewhat disingenuous on their part, unless we are setting forth their rights here so that they have a full understanding. The Town of Newburgh Zoning Board of Appeals has jurisdiction over orders, requirements, decisions, interpretations of the Code Compliance Supervisor pursuant to Town Law Section 267, including those with respect to vested rights. The Town Board further acknowledges and recognizes that in the event the processing and consideration of a pending application has been delayed prior to the enactment of local law number 2, pursuant to the contemplated resolution, beyond the applicable time frame set forth in the code or New York law, the local law cannot serve as the basis for the order official having jurisdiction over the application to refuse considering the application. Board, any questions regarding that? We've asked them. Essentially, we were saying the decision had not been made in a timely fashion, and then the applicant still is entitled to that decision.
Any questions for Mr. Taylor?
Now, there were further findings that are set forth in the resolution. Those have to do with the implementation of the comprehensive plan update over the course of the past several years. And the finding is based upon personal knowledge of board members that the town has addressed and continues to address legislative and administrative action items recommended by the adopted comprehensive plan update in a deliberative and serial fashion in accordance with prudent management of the town's financial resources and budgetary restrictions. The town wasn't able to do everything that was recommended by the comprehensive plan update, including the enactment of adult business studies, and its resources have pending, but to the litigation that arose from the implementation of its comprehensive plan action items. There were challenges to previous action plan items. Those challenges required considerable resources, both in time and expense from the town. So the fact that it's sort of taken several years to pick up every item is a result of that. The proposed resolution also includes a finding with respect to the dire necessity for moratorium action. And the reason the town board views there as being a dire necessity is as follows. Provisions are presently absent from the municipal code to control the siting of adult-oriented businesses. The current code interpretation, property owners and developers can add adult-oriented business activities to certain existing permitted uses, such as eating and drinking places and retail and personal service stores, or obtain approvals for new uses in those categories without any ability on the part of the town to regulate the location of such adult-oriented business activities relative to certain sensitive sites, including, for example, schools, places of worship, parks, and residential districts. That's under current interpretation. Without an application requirement or process in place, the town is unable to accurately account for the number of adult-oriented business activities that currently under consideration or proposed and their proximity to sensitive sites in the town. That is the reason this board decides to act, considers there being a dire necessity, and say there are so many applications pending. But the fact is, in many instances, applications aren't required under the current code. So, are we going to go out and call everyone up and then rely on the honesty of their answers? And finally, there's also a statement here that, given the record that's created, there is concern that someone who challenges the board decision will state that the board is acting because it's been faced with numerous comments and submissions, written and oral, of general community opposition to particular projects, which may be subject to the board wants to make it clear that in the absence of evidence related to substantial legal grounds for making these determinations, it's not the case in those statements of general opposition. Can't. If that's the basis for its decision is constructive. And it is more than that. So that's the proposed resolution for the board's consideration, and as well as proposed local law with the addition of that particular footnote. So the board to decide whether it wants to proceed in this fashion or in a different fashion or not proceed at all.
Okay. Thank you, Mr. Chairman. Any board members have any questions? Comments, Mr. Taylor, just made? The local law resolution? No? With that, I'll make a motion that we adopt the resolution, local law number 2, 2012, imposing a 6-month moratorium on permits and approvals of businesses as presented by Mr. Taylor.
Wait, that's what subject number 1.
Yes, that's what, with the footnote and the explanation Mr. Taylor provided.
Do I hear a second? Any discussion on the motion?
Yes. I'm going to explain why I'm going to vote the way I am. I'm going to do it before we call a roll.
You may.
I do not feel that this law is a permanent solution. This is only a temporary fix. My belief is that we should jump right in to change the zoning for the time limit. For that, I'm going to vote no.
Anyone else?
I guess I'll give my comments now, since I can't give them when I give my vote.
You can do it either way. This is
Oh, well, Mr. Zaretsky has told me that I can't make comments when I'm giving my vote.
And I'll say it again.
But
I say it.
I realize both sides. The Santa Monica has spent money there, and I feel the homeowners in riding through the neighborhood and everything have spent a great deal of money, investment in their homes. I feel that one of the biggest investments people who are homeowners make is into their homes. I agree with Mr. Woolsey in the fact that, yes, is this a permanent solution? No, it's not. Do we need to study it further and find and put in our zoning a permanent solution to this problem? We are an area that is growing. We are getting big influxes from the city and all like that. So I think we have to look to protecting all of the residents in the town of Newburgh. So I am giving you my explanation in advance as to how I'm going to vote. Thank you, Mr. Booth.
Wayne, maybe I'll just say a quick word here, but I too feel that we should be moving ahead as quick as possible with zoning, and that's what I really plan to do. So that's why the reason why I'm going to vote tonight.
So I'm a little man on the totem pole, it's my turn.
Okay.
Well, first of all, for the 5 members of the board, this is a very hard decision to make. So we all toiled over this for quite a long time. It is my core belief that a moratorium should be put in place town-wide, although probably not judicially prudent. So that is why I am going to vote the way I'm going to vote.
that for a roll call on the motion.
Mr. Woolsey,
Regrettably, no.
Mr. Piaquadio,
No.
Mrs. Green,
Yes.
Mr. Bello,
Yes.
Mr. Booth.
Yes.
3 yes, 2 no.
With that, for a motion to adjourn.
So move.
Motion was made and seconded to adjourn at 3:31 p.m. Mr. Woolsey,
Yes.
Mr. Piaquadio,
Yes.
Mrs. Green,
Yes.
Mr. Bello,
Yes.
Mr. Booth.
Yes.
The meeting of April 2nd, 2012 is hereby adjourned.
Thank you. Thank you, everyone.